All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number SA140256, Allen versus Sanders. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Our calendar outside had a typo on it. Each side will have 20 minutes for argument. I think it gave 20 minutes to one side and 10 minutes for the other, but you each get 20 minutes. And Petitioner's Counsel is responsible for watching the clock and reserving any time for rebuttal that you may desire. We've read the briefing in connection with the petition for special action, and we have conferenced the case prior to argument. As you know, we sent out questions, and we've received some responses to those questions already. With those preliminaries, counsel for the petitioner may proceed.
Thank you, Your Honor. May it please the Court? I'm John Curry. With me today is Jeremy Bogart, and we represent Samantha Allen. What I wanted to address first is the two cases upon which the trial court primarily relied and which the state cites in its filing as supporting the notion that relation by affinity is a concept in the law that requires some kind of statutory interpretation and requires looking beyond the language of the statute. And the first one of those cases is the Michigan case, State against Armstrong. In that case, I talked about it a little in my filing, but beyond that, I wanted to look at that case in some depth and talk about why it's not a case that this court should follow, and it's not a case that really supports or is worth following. And you have to start with Michigan law at around the turn of the century.
Even before I was born.
Before any of us were born. I know I was born in Michigan. There was a 1907 case in Michigan, and that was Bliss against Tyler, in which the court said that relation by affinity means the relationship between a spouse and the blood relatives of that person's spouse. No farther, it went no farther than that, and the Michigan court was pretty clear, Michigan Supreme Court, saying this is what affinity means, it's got a specific meaning. Relation by affinity is the relationship between a person and the blood relatives of that person's spouse. In 1977, in the context of a sexual conduct case, that's the People against Denmark in Michigan, that's a Court of Appeals case. In that case, the court says exactly the same thing. They said that the term affinity is not an unusual or esoteric word. It's not uncommon. It's not being used in any extraordinary context in the statute at issue. And it said, our courts have provided clear legal definition of the concept on numerous occasions. And they cite the language from Bliss against Tyler, which says affinity is the relation existing in consequence of marriage between each of the married persons and the blood relatives of the other. So that was the background from which the Armstrong court approached the question of what relation by affinity meant in the incest statute that it was dealing with. Now, looking at normal, typical rules of statutory construction, the law is clear. It's the phrase or the concept of relation by affinity had a clear meaning. And there really wasn't much for the Court of Appeals in Armstrong to do other than apply that clear meaning. But they didn't do that. The court didn't do that. Instead, it looked to a 1950 Washington case, and a state case called In Re Bordeaux, and they cited Bordeaux for the proposition that the meaning of the idea, or the meaning of the term relation by affinity depends on the context in which it's used. And it went on to say that affinity is not capable of precise definition. It depends on the context. That's the proposition for which it cited Bordeaux. There's a couple of problems with that. The first problem is there was no need to go beyond the statute. There was no need to go looking to Washington law because Michigan had its own law and Michigan's law was clear. The other problem with that is that isn't what Bordeaux says. Bordeaux was not deciding whether the concept of relation by affinity was context specific. What Bordeaux was dealing with is the question of whether a relation by affinity survives the death of one of the spouses. That was the issue before it. And in a 10 or 11 page review and survey of cases, what the Bordeaux court came up with is that whether a relationship by affinity survives the death of a spouse depends on the context. And generally speaking, what they found in looking at these cases was that if it involved an incest statute or a jury qualification kind of an issue, then the courts found that the relation by affinity did not survive the death of the spouse. And there's sort of an oft-stated concept in the law that the Bordeaux case was dealing with, which is that the death of a spouse terminates any relation by affinity. So that's what it was looking at. That's what it was getting at. In some contexts, the incest situation, the jury qualification situation, the courts found that it did not survive. In other contexts, like insurance cases, workers' comp cases, where a beneficiary would lose any recovery, courts tended to find that the relationship did survive. So the point is, the issue being addressed by the Bordeaux court was whether a relation by affinity survived the death of a spouse. And the Bordeaux court did not hold that relation by affinity was a vague concept that needed statutory construction. So the long and short of that is that Bordeaux doesn't support what Armstrong says it supports. It stands for something really different. And those are the reasons why I'm going to urge the court not to follow Armstrong, not to rely on Armstrong. First of all, it strays from normal statutory construction by saying, by ignoring its own, the well-established law in Michigan to the effect that affinity means just what the Arizona courts have said it means in Ramsey and in Tensa. And then they go on to get where they wanted to go by misreading Bordeaux. And that takes us to State against Brown, which is the New Jersey case. It was a 1997 case that followed Armstrong. And that case is distinguishable from ours in one really important respect. In the Brown case, the court specifically notes that there's no definition of the term affinity in the statute, and there are no New Jersey cases that provide any kind of a definition. So unlike Arizona, unlike this court, the New Jersey court in Brown was writing on a clean slate. There was no well-established meaning of the term affinity in that case. That's a distinction here, and it's a distinction that really matters. The second thing that about Brown is they cite Armstrong and they follow Armstrong, and I think Armstrong is not a case that provides a real example of principled appellate decision making. It's not a case that ought to be followed. Beyond that, there's a couple of comments I want to make about the brief that was filed by the amicus, the amici in this case. In that brief, they talk about homicide survivors and essentially ask the court to find that Cassandra Deal was a victim in this case because she's a homicide survivor. Well, sadly, that is a very large universe of people. It really is anybody who has a friend or a relative who they lost to a murder or to a drunk driving type accident. It's way more broad than the language of this statute would permit as far as a test for qualifying as a victim. And it really is too vague to provide any meaningful standard for determining that. And if you actually look at the definition in 440119, it is really very narrow. And it's not the affinity part that makes it narrow, it's the related to the second degree part that makes it narrow. The only people that are related to someone within the first or second degree are, well, in the first degree it's your spouse, your parents, your child. And to the second degree it's grandchildren, grandparents, or brothers and sisters. So that's really a very narrow reach. And there's some irony to that. In the notice of legislative history that the state filed, they noted the testimony given by then County Attorney Paul McMurdy, who talked to the Judiciary Committee. And in his discussion of this issue, he said, County Attorney's Office wants to put a face on this, and he gave an example of a case where an aunt, the murder victim's aunt, wanted to give a victim impact statement at the trial, and she wasn't allowed to under the old statute because she didn't qualify as a victim. Well, the irony is she wouldn't qualify as a victim under the new statute because an aunt is not related to somebody to the second degree. They're only related to the third degree, just as a cousin is only related by to the fourth degree. The point is, this really is a narrow statute, and by asking this court to open it up by essentially just attaching a step to anybody in front of anybody and saying that that person qualifies as a victim is really beyond what the statute intended. To sort of sum up, relation by affinity is a legal term of art. It has a precise meaning in most jurisdictions, including Arizona, and that limits it to the blood relatives of the spouse. The legislature chose that. They drew a bright line, and there's no real room for statutory construction in this instance. The court ought to apply the definition that is set forth in Ramsey, and under that definition, relatives of relatives are not related by affinity, and that's what the court should find.
Is Amy related to David Deal?
Setting aside for a moment the question that the court raised as far as whether she's really a stepsister, if we assume that she's a stepsister, she was related to David Deal by affinity because she is a blood relative of David Deal's spouse.
So that makes her daughter, and that makes her his daughter-in-law?
No, that makes her his stepdaughter. David Deal is married to Shirley Deal. Shirley Deal is Amy's mom. Therefore, David is Amy's stepdad.
But I thought relatives pre-existed the marriage. If one looks at it that way, and looking at most of those dictionary definitions that I included in my filing, she wouldn't be a stepdaughter if you look at it that way, because she's not a daughter by a former relationship. She's a daughter by a subsequent relationship. She's Shirley's daughter by a subsequent relationship. So if you look at it, if you look at the definition of stepdaughter or stepsister, the way most dictionaries describe it, with that temporal element, then she isn't David's stepdaughter. If you look at it more broadly and say just because she's Shirley's daughter, she's therefore David's stepdaughter. That depends on how you look at it.
But she would have the first degree of affinity with David.
Yes.
But then you can't go down to Cassandra.
Again, you can't go down to Cassandra because kin and kin are no more related than they were before.
And Ramsey only partially answers the question before us, correct? I mean, this would be an extension using Ramsey's platform, but doesn't this go beyond Ramsey?
Do you mean what I'm asking goes beyond
Yes.
Ramsey? Ramsey doesn't say that blood relatives are not related to each other by affinity.
And it doesn't say they are.
It doesn't say they are. What it says is affinity, relation by affinity is the relationship of a person to the blood relatives of their spouse. And the focus of the analysis and the focus of the determination is on the people being married, not the people at the periphery. So,
Ramsey defines at least affinity, is what you're saying.
yes. And it defines it in a way that excludes Cassandra Deal from being related by affinity to Amy Deal. I'm going to save the rest of my time for rebuttal. Thank you.
Good morning. My name is Lisa Marie Martin, and I'm representing the state of Arizona. I did not file written answers to your questions, so I'm going to go ahead and answer those right now. The first one is the, excuse me, if David is not Amy's biological father, and we have these common definitions, the stepchild is a child of one spouse by a previous union. Given these common definitions, were Amy and Cassandra stepsisters? Yes. The answer would be Cassandra is a child of David and his former wife, Shannon. When David married Shirley, Cassandra became Shirley's stepdaughter. And when Shirley had Amy, even if she fathered, or even she didn't father Amy, even if Amy was fathered by another man who was Kenneth Greased, it was still during the marriage to David. So Cassandra and Amy became stepsisters. That marriage has never been legally dissolved, so Cassandra is still Amy's surviving stepsister.
Well, but all of the different, all of the definitions of step relatives that I've seen have the child's birth precede the marriage. So you would end up with an odd situation that any time one of the spouses has an extramarital affair, that immediately there's a step relationship created, and that seems rather odd to me.
Well, actually, it isn't, Your Honor, and I'd like to address that in the context of the defendant's answer to this question. What the defendant argues is that Amy and Cassandra were not stepsisters because Amy was Shirley's daughter by a subsequent rather than a former relationship. Well, they use the word relationship. Well, affinity, even in the broadest terms, is relationship by marriage. There has to be a marriage. This relationship, or the sleeping with Kenneth Greased, that was not a subsequent marriage. So under their definition, Cassandra would be the stepsister of Amy, but Amy would not be the stepsister of Cassandra, because Cassandra is the child of a former marriage. She is the child of a former marriage. She comes into when he gets married again.
I've no doubt that she is the stepdaughter of Shirley, but I don't know how that applies as far as Amy goes.
Well, Shirley and David get married, and they have there's a child born during that relationship. She's she's the natural daughter, Amy. She's the natural daughter of Shirley. Cassandra is the stepdaughter of Shirley. Amy, if we don't accept the parental presumption, Amy is at least the stepdaughter of David, and David is the natural father of Cassandra. So there has to be, under those definitions, there has to be a stepsister relationship between Cassandra and Amy.
But doesn't that conflate the doctrines of consanguinity and affinity, because you go up under your analysis under affinity and you come down under consanguinity, and it's got to be the second degree of affinity, and that's the link that I'm not sure where that attaches between Amy and Cassandra.
Well, I think there's two ways that you could look at that. If you look at the definition of under victim, under the actual language under 13-401-19, it says other person related to the person by consanguinity or affinity to the second degree. I think that could be reasonably interpreted that those are not mutually exclusive. So you could count up one leg, so to speak, by consanguinity and count down one leg by affinity and end up with 2 degrees by consanguinity or affinity. I think that's one interpretation.
Well, I find this confusing, so forgive me. I am paying close attention, but I'm always looking at my flow chart here because of this complicated situation. In preparing for this argument, we have looked at similar victims' rights statutes all over the United States. We've looked in other contexts to try and help us understand how we should be looking at our statutory language. And I don't recall seeing any case anywhere that mixed consanguinity with affinity to provide that relationship link. I can't think of any case that approached it in that manner.
And I haven't found any case either, Your Honor, but I'm saying that it's a possible interpretation. What the state believes is a more reasonable interpretation is to define affinity more liberally. Now,
And what would the definition be?
the definition would be basically still stay within the second degree, but any relationship by marriage. So even though we have the definition in Ramsey, and the state agrees that there are narrower definitions that come from the 1893 case, and that many states for years and years applied those definitions of the blood relatives of one spouse and the blood relatives of the other spouse, and that would not include this relationship, and all the diagrams. The state agrees that under that narrow definition of affinity, those diagrams are correct, and the defendant's position is correct. And the state also agrees that Ramsey put that narrow definition of affinity in the case in 1992 using a 1979 dictionary definition. However, the actual holding of Ramsey was about consanguinity, and it was about adoption, that even though there's an adoption, it never actually stops the blood relationship between the blood parent and the child. And there's even another case in Arizona, State versus Martinez, that says even though a mother gave up a child for adoption, she could come and give a victim impact statement at the sentencing for her child that had been murdered, because consanguinity is never severed. So that's really what Ramsey stood for. And Ramsey is also not only an older opinion, but it's not in the context of victims' rights. That wasn't the official holding of Ramsey. This court does not have to follow another decision of another panel of this court from 1992, and the victims' rights statute has been broadened since then. Again, there's not much legislative history.
But let me interrupt, because it was broadened after Ramsey, and we presume that the legislature knew of the Ramsey definition of affinity, and it selected that term. So why would we not assume that's exactly what the legislature meant?
Well, because this wasn't even the real holding of Ramsey, and also if you look at the very limited legislative history there is, even though they used the word affinity, when you actually look at their face sheets, they say related by marriage. Again, that's not much of a legislative history. But there are definitions existing today that say that affinity is relation by marriage. I mean, there are so many words that have been, everyone thinks they know the definition, even the word marriage itself. Who could have ever thought, even, not so many years ago, that marriage could mean a union of two people of the same sex? You know, I mean, it may be, some states may be hard pressed to find a case that would define that. Things have changed, even blended families, and the court should interpret the victim's rights statute liberally.
But isn't that for the legislature to do, not us? If the legislature wants to broaden the category, as many states have done, some going so far as to say neighborhoods and homeowners associations are victims, isn't that for the legislative branch to do, and for us to apply the meaning of the term affinity as it seemed to clearly exist at the time the legislature chose that term?
Well, Your Honor, it's never been interpreted. It has not been interpreted, and it is a court's job to interpret a statute. And it really, yes, there's a definition in that case. It was not the holding of the case. It was not a victim's rights context. And the court can come up with a reasonable interpretation that is not at odds with the legislative, the definition in the statute itself or in the legislative history. So the court could make that interpretation that a step sibling, I mean, think of it this way, the defense doesn't even argue that a step mother and a stepchild or stepfather and a stepchild are related by affinity, because that would fit the narrow definition, the nursery rhyme definition, and the Ramsey 1992 definition taken from the 1979 case. But isn't that counterintuitive? They're no more blood related than Amy and Cassandra. Isn't it counterintuitive that a stepchild and a step-parent, that they would be victims for each other if one of them were murdered, but the step-sisters wouldn't? And we can't just make an ad hoc determination, say, oh, it's Cassandra and Amy weren't that close. They hardly ever saw each other. I mean, because you can say that about a blood brother and sister. They could be estranged, but it would still be a victim.
You know, I understand the point you make, and it's a strong and powerful point. And if we were sitting over in the House or Senate Judiciary Committee, your point would be very well taken. But that's not what we do. And what I'm struggling with here is that in 2005, the legislature did expand the definition of victim. And so in that sense, it added additional people through consanguinity and affinity to the second degree. But those terms do have some meaning. And and Judge Downey really asked this question better than I can. That's what we are supposed to do, is to define the words as the legislature used them, not come up with our own perhaps expansive view after the fact. And
Judge Norris,
this one's a troublesome one.
I wonder if when in addressing the second question, and I'm not trying to get off point, I'm actually trying to answer the question through that. Not that I'm trying to evade your question. I'm really not. And the question is, are adopted children considered blood relations for purposes of either consanguinity or affinity? And it cites the definition of consanguinity and affinity in Ramsey. My answer is, or state's answer is, these are neither blood relations, nor are they relations by affinity per se. If you look at the adoption statute, which is 8117, while the relationship of the natural parents and the child are legally severed, and the privileges, rights, and other legal consequences now go to the adoptive parents and the child, as though they were born to the adoptive parent in lawful wedlock. Ramsey itself says that a decree of adoption does not sever consanguinity, so it can't be the same. The adoption relationship, although it severs all and it gives them almost the rights as if it was in natural wedlock, it doesn't sever consanguinity. It also doesn't take into account, suppose a single parent adopts, which we have too. But also, could it be a relationship by affinity? Even though it says this is like it's the child's being born in lawful wedlock, it's also not by affinity, because it's not from a relationship by marriage, which is the definition of affinity. So really what it is by court order. So if you try to look at then where does that fit? Where does an adoptive parent and an adopted child fit under the Victims' Rights Act. I guess the only reasonable explanation is that they would have to fit under the enumerated people, which are, that include person, spouse, parent, child. So they would have to be in the place of the parent or the child. Is that an interpretation? Is that an expansion? Or is that just something, that you would have to go to the legislature for to find out that? Because I think that has been, that's a fair interpretation, but it's also not specifically written in here or by court order. You still have to take an interpretation.
Well, it does begin, the sentence begins with on entry of the decree of adoption, so that is a court order. So I don't think we have to interpret the.
Right, I'm just saying that the victim's rights, it says lawful representative, and do they come under the victim statute? Would they come under, there's no thing in there or by court order, but would a adoptive parent be a victim, a surviving victim, as a lawful representative or in the place of a parent?
Well, if I read 8117A, and it says all the legal rights, privileges, duties, obligations, and other legal consequences, I would think that based on an order and both by a court order and by state law, they would become a parent for purposes of the Victims' Bill of Rights.
Okay. Well, that actually was my answer, that was the most reasonable interpretation. To answer your question, it was neither consanguinity nor affinity, the adoption, but it came by coming in the place of.
Well, Counsel, what's your view on the application of the paternity statute
Okay.
and the presumptions?
The paternity statute, I'm sorry I haven't gotten to that yet. If you notice, and I think it's in Appendix 5 to the special action, is the state's response to the original motion for deposition of Cassandra. And the state's response, that was a major part of it, saying that there's a presumption of paternity because Shirley was married to David for at least 10 months before. At the time that she gave birth to Amy, David's name was put on the birth certificate. But then this was actually litigated in the trial court level. Shirley gave an affidavit, and my understanding, I did talk to our trial counsel before I filed the special action, that the state had conceded that presumption had been rebutted by clear and convincing evidence, which is why I did not argue that in the special action.
Thank
We
you.
appreciate your response on that.
So I think that answer was pretty quick. And like I said, the legislative history was really quick. And just to address a little bit, I did listen to that tape also where Paul McMurdy, and I'm sorry if it was difficult for the court to access that. If I had a way to getting it typed fast enough, I would have given it to you in a typed form. But he does say aunt. I pronounce it aunt because I'm from Rhode Island. But he does say aunt. And again, this is not the issue before the court, another issue of statutory interpretation. But could the victim statute of the 1344A be reasonably interpreted, those last lines, person related to the person by consanguinity or affinity to the second degree? For instance, could consanguinity be even past the second level, and only affinity is restricted to the second degree? Because I agree that an aunt is the third degree. So, I mean, that was the only reason I could think of why he would have said that. And, I had never thought of that interpretation. It wasn't in the minutes that were written. And when I heard that and I heard aunt, I immediately thought aunt is the third degree because I have been looking at all these charts as well and now know all these degrees. So that's really all that I had on that. On the questions, excuse me. My response to the cases on Armstrong and Brown, I'm not really saying, the state isn't really saying, oh, you have to follow those cases, or that we're not saying that you need to dissect Michigan law, but that if you look at Armstrong, just what the court did, it said, these cases that had these other definitions, they're 60 years old, and they were for a different purpose. And now we have this, sexual misconduct statute. We have these people that live in the same house, a stepbrother, stepsister, and we think the policy behind that means that we should expand the definition of affinity. And it's just analogous in the sense that, and again, a policy argument that a definition of affinity, a liberal definition of affinity, would also serve the rights of the victim's rights statute, which should be interpreted liberally. In terms of the Brown case, where the court said we have no cases defining affinity. Again, the state agrees that affinity was defined in Ramsey, but it was not the holding of Ramsey. It was not necessary for the holding of Ramsey, and this court, can still interpret affinity in terms of liberally interpret it by its common sense meaning. You say that you've looked at statutes and dictionaries all over the country, and I know that you have seen that there are much broader definitions of affinity than the nursery rhyme version. And the state believes that this court can make that interpretation of that term in today's world. Thank you. I'm sorry I used up all my time.
Oh,
You've apparently had a busy week, right?
Oh, did you hear about that?
Yeah.
I didn't think I should mention it because they would think that they'd think I was minimizing you.
no.
Well, Scottsdale Crime Lab's important too. And Mr. Curry.
All right, the state seems to concede that Arizona law has defined affinity, and they've defined it in a way that excludes Cassandra Deal from being related by affinity to Amy Deal. They're asking you not to follow that established definition, mostly, I guess, because they don't like it. It's not as if they're pointing to something that the legislature said to suggest that they didn't mean affinity when they said affinity. It's
What
not.
about Ms. Martin's point that if one goes to the fact sheet that accompanied the 2005 change, in the fact sheet it referred to the relationship by blood and by marriage, not by blood and affinity. It used the word marriage. Does that suggest then that perhaps the legislature was thinking in lay terms, affinity equals marriage?
I don't think so, Your Honor, and here's why. For the same reason, I mean, what they're doing is making a translation of the legal term, a rough translation, just as consanguinity is a term that isn't a term that one comes across in normal life. So they simplify that. Consanguinity is blood relation. They don't change it, and it doesn't mean something different. They just used a different word to try to describe it. It's a shorthand.
And I should have asked Ms. Martin this, and I might ask Judge Downey to give me liberty to let her have another 35 seconds. But if the legislature was using affinity in more of a lay speak as marriage, is, however, then it's appending the second degree inconsistent with that?
No, it's not. Because
Wouldn't your response be, yes, it is inconsistent? Because if it's just marriage, who cares about degrees then? Does it matter?
yes, it does. And the best answer that I've come up with in looking at this is when you're trying to determine a degree of relation, when it's an affinity relationship, you take the person that is related by affinity and you treat them the same as if they were related by blood. And I came across that in some charts and some statutes in other states. So if, for instance, I'm related to my wife to the first degree. So if we had to determine how she was related to my brother, are you with me?
I think so.
Okay. We take her and we plug her into the chart as if she's me, and she's related to my brother to the second degree.
I think
Or first degree? Second
degree.
degree?
It's first degree.
First degree,
Yes,
okay.
first degree, yeah.
And so if you take a stepchild and you want to determine what that child's relationship is to a grandparent who is related by blood to the stepfather, well, this is so complicated when you try to do it without a chart. The short answer is you take the person who's related by affinity and you plug them in as if they were related by consanguinity, and you count up and down from there. That's the short answer.
And you would disagree with Ms. Martin's suggestion that maybe you could go up on consanguinity and down on affinity, or vice versa. You've got to follow the degrees under the same rubric, either consanguinity or affinity.
Yes, I think that's right. I'd kind of have to map it out to know for sure if I agree with that, but that sounds right.
Well, I think that was your point in distinguishing the case, the nepotism case involving the sheriff. I think that went up under the state's analysis under one and down on the other theory, but anyway, just get us further confused.
Are you considering it as a step relationship, or are you arguing first that there's no relationship at all between Cassandra and...
I think what I'm arguing, Judge Howe, is that it doesn't matter whether you call it a step relationship or whether you call it an in-law. What matters is
affinity relationship.
Right.
Okay.
And whether you call it a stepchild or a stepsister or a stepmother or a step-grandmother, it's not the step that matters, it's whether it fits the definition of the relation by affinity, which is where I think the state's wrong when they say it's counterintuitive to include a step-parent, but not a step-parent, but not, to say that a step-parent is related to a stepchild, but one stepchild is not related to the other. That's not counterintuitive. Those are really very different relationships, and the charts that I included in my filing demonstrate that. There is, in this case, Shirley Deal is married to David Deal. Cassandra Deal is a blood relative of David under the traditional accepted definition of relation by affinity. Shirley is related to Cassandra by affinity. But that doesn't mean that every step relation is related by affinity. It has to fit within the framework of that test. And under that test, blood and blood, relative and relative, kin and kin, are not related. And I think it might help if you look at it from the point of view of who's getting married here. If you look at it from the point of view of the spouse is acquiring a bunch of relations by affinity, but that spouse's relatives aren't. I mean, when I married my wife, my brother-in-law didn't choose me, but he's stuck as my relation by affinity. I'm not related to his wife. It's got nothing to do with it. It's who my marriage is what determines who my relations by affinity are. So when you stretch that out and you say we have a child...
Forgive me, she's not your sister-in-law by marriage?
No, she's not. She's not, well, my sister-in-law are my wife's sisters. They're my sisters-in-law, but really, my brother...
Their husbands are not your brothers-in-law.
Right. They're not. You might think of them that way, and I like all my brothers-in-law, and their spouse is fine, but, technically they really aren't any relation to me. But I had a thought, and I lost it. I think the central point here is there a reason for the court to depart from the traditional definition? There's nothing in the legislative history that suggests the legislature meant anything other than the traditional definition, and the state really hasn't offered you any other reason other than we kind of don't like it, and that's not a good enough reason. And
Your time's up, so if you want to sum up very quickly.
That's
Did
it.
you hear from Ms. Martin?
I would like to.
Did you want to respond to Judge Norris's point?
And could you repeat the question? I mean,
Right, and
I
I'm
think
sorry
I know what it is,
I
but-
muddled it. My question was this: the fact she does use the word marriage in lieu of affinity in discussing what the statutory changes we're going to do. And so, taking that, your argument is, well, that must mean they intended more of a common layperson definition of affinity, really just means marriage. If that's the case, then how would I square that with their appending to the definition of affinity being the same as marriage within the second or to the second degree?
Then you would still have the degrees. So you would, within the second degree, would include siblings. And so siblings by blood are brother and sister or half brother and sister, and then step siblings would be by affinity to the second degree. If you just consider marriage to affinity to be marriage and go to the second degree, and I think that Mr. Curry agrees with this, that there is case law and it's in the briefs that say when you calculate them that the degrees of affinity and the degrees of consanguinity are the same. So there was actually someone, I think he said, well then his wife's brother, it would be his wife to his brother, they said would be the first degree. That would actually be the second degree, because it would be just like him to his brother. You see what I'm saying? There's the first degree of affinity is him to his wife, and then him to her brother, her blood relative, would be the second degree. And that's under the narrow nursery rhyme version. Did I just confuse things more?
No.
Okay. Thank you.
Let's see, Michigan, Rhode Island, and I'm from Arkansas, so of course all of this just is very confusing in that context. But actually, your arguments were very helpful. We appreciate you answering our questions, and we will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.